Good afternoon, Mark Rucci for Appellee, State of Maine.
Thank you. And Mr. McNamara, if you're ready to proceed, we'd be happy to hear your argument.
Thank you. May it please the court, Counselor. I'll begin by discussing the child of defense to kidnapping. All three steps of statutory interpretation favor the conclusion that stepchildren are encompassed by the defense.
Can I ask
please.
a little tidying up question?
Yes.
Is this ready? I saw a motion for a new trial was deferred until after sentencing. Was it ever ruled on?
No, it wasn't. I believe it was withdrawn as well.
It was withdrawn.
That's my understanding of that motion. So all three steps of the statutory interpretation favor the conclusion that stepchildren are encompassed by the defense. First, the plain meaning of child includes stepchildren. Certainly, step-parents throughout Maine view their stepchildren as
Isn't there
children.
a substantial difference, though, in what underlies the reasons for that to be a defense? First of all, a legal parent, has the right essentially to control the location, to move the child about, whether the child wants to be moved about or not. And a step-parent doesn't have that legal authority.
Well, a step-parent has that authority when acting in loco parentis.
It may be delegated to that parent by the legal parent in some circumstances, but as a matter of law, that step-parent does not necessarily have that authority, does it?
Well, I think there are also circumstances that could be covered, I think, by what Your Honor is intimating. There are circumstances where it's almost like a competing parental versus step-parental interest, and how would those situations be covered if there were some kind of dispute between the two?
What I'm intimating is that the policy reasons behind permitting there to be a defense that the defendant is the parent of the child, or it is the child of the defendant, is that there are legal reasons. That parent then therefore has legal authority to do certain things with that child that other people would not have the authority to do, including moving that child and potentially secreting that child from others.
Well, I think there are legal components, certainly, that we could be referring to, taking your daughter or your son and asking for them to have certain medical treatment, for example. But circumstances like in this case, where the judge repeatedly found that my client was acting to protect the individual who was, quote unquote, kidnapped, restrained, I think that's something we expect from step-parents to act in the interest of those stepchildren, is that they are protecting and looking out for the best interest. So I think to the extent that it's going to be covering those situations, what we look to is the limited intent we have.
But what about in this case, the problem was that he, in his mind, may have been acting to protect,
right,
but it did not appear to be that way to other people.
Right, and I think that's, I mean, when you're talking about in loco parentis, that's an interesting question. How does that work, that matter of intent? Certainly his intent, as the judge found over and over again, was not to harm, not to threaten, not to intimidate, but to protect. And I think that is, as a father and a stepfather myself, that's like job number one, is to protect the kids.
But in this instance, part of that protection extended to removing the child from the child's biological mother.
Well, I don't see why it doesn't. So my client thought he was protecting, in part, this individual from her mother, in part. And if that's a legitimate concern, I think that should be in loco parentis. You're doing that for a purpose of protecting this child. The proper charge in a circumstance, I think, where there is some competing interests between a parent and a step-parent who has custody of a child, would be criminal restraint, and that could have been charged under Section 302 here. It's a Class D charge as opposed to a Class A charge.
I think the legislative history with respect to criminal restraint indicated that what was contemplated by the legislature with respect to that particular statute were disputes of custody between legal parents.
This circumstance would have been covered by, I have it in here, 301 302(1)(a)(3). So that's where there is a situation that somebody is being taken away from their parent. And that would be the appropriate charge in this case. But when we take a look at why kidnapping has been elevated to a Class A crime, I think there's a difference in why we're protecting step-parents who have this duty to protect and act in best interests and to take to places that sometimes kids don't want to go. The legislature and CLAC indicated that they don't want to have
Are you
overbroad prosecution.
defining, under your test, would it be anyone who's married to the mother? Would they have to be married? Is in loco parentis broader than that? It can be the boyfriend? What's your test?
Certainly for this case, the test is simply that the judge found that he was acting in loco parentis to protect,
Well, that's not, I was going to say, the judge didn't actually find he was acting in loco parentis.
It wasn't asked. But I think we can infer from the findings that the findings are very clear: protect, protect, protect all over the findings. And I think that's really the fulcrum. Other states, other jurisdictions have found caregivers, perhaps a daycare provider, acting in loco parentis.
So your definition would be very broad. Anyone acting in the view of the fact finder in loco parentis.
That is, I think, the fulcrum of the
Whether or
analysis.
not
but
it
I
was
think,
appropriately.
well, I think stepchildren, step-parent, is a limitation in addition to the in loco parentis. That's all we're arguing.
Isn't the fulcrum legal authority? So, for example, if the step-parent decided that I need to protect this child from the COVID epidemic, and biological mother is dead set against vaccination, does step-parent, stepfather, or step-parent have the right to take the child and have the child vaccinated?
No, that's a different set of circumstances, obviously, where we're not talking about kidnapping anymore.
Well, we're talking about legal authority without the parent's consent,
Well,
without the legal parent's consent.
This court construes statutory language, step one, according to its plain meaning, not
And
its
on that
legal
point,
meaning.
you say that the rules of statutory interpretation favor the step-parent being deemed to be an appropriate legal authority.
Yeah.
But depending upon the Black's dictionary, I think, comes up with the definition of parent as being the legal parent.
Well, I think that that's one of the additions in Black's. I think certainly, and again, Black's is a legal dictionary where it's going to be focused on the legal definitions. If you look back at Merriam-Webster, at other dictionaries cited by the 10th Circuit in the case resolving a very similar question, they said this is unambiguously encompassing stepchildren, step-parents.
Let me try this. In Maine, haven't we gravitated to the perspective that we talk about under the Maine Parentage Act, that we talk about individuals who have legal authority with respect to the child and the ways that one can go about obtaining that legal authority, i.e. de facto parentage?
We do, and that makes sense in the parentage aspect, where we're talking about legal rights to administer COVID vaccines or to make decisions about where a child goes to school. That legal status is very important.
Or the legal right to take a child and secrete that child somewhere.
Well, take a child to protect a child.
Well, that may have been his subjective intent, but there was nothing objectively reasonable about there.
Well, it was also the intent that was found by the judge.
I understand.
And intent here is an element of the crime. And my argument is that when that intent is covered by, in loco parentis, an active in loco parentis, if you will, that should be, and it is a defense, according to the plain language of the statute. Not just the plain language, but also some of these aspects of the Maine Parentage Act, for example, have not come to fruition until recently. This statute was enacted in 1978, 1976, I'm not sure, the 70s, at a time where the concern was we don't want parents being overly prosecuted for quote-unquote kidnapping. And that's the concern that we have here. We have
It's not really here. Well, I guess what my concern is, if we accept your definition that step-parent has these prerogatives and these rights, don't we blow the lid off the protection the child would have with the natural parent, with the I'll say the actual parent? And it's a continuum here where it might be, the spouse, and they haven't taken steps to get legal rights, but the spouse of of the parent of the child to Justice Connor's saying, what about just a random boyfriend or girlfriend living at the house there, knows the kid by first name, and they do take them away and intend to secret them from the other parent, as happened here. He admitted he was trying to take it away and take the witch. Where do we draw the line on this continuum that you're hypothesizing?
So to clarify, and to go back to Justice Connor's question, there were two components of my test. A step-parent, so marriage, and the other part was in loco parentis. But to ameliorate those concerns about, and I know I've made this point already, but there is a charge that would have been appropriate here. It's criminal restraint under Section 302. It's a Class D crime, and that gulf between Class D and A is very significant in this case, where...
In the little bit of time remaining, can we go to the other issue?
Please.
Are you suggesting, I just want to clarify, are you suggesting that it cannot be kidnapping because it cannot be secreting, and putting aside the parent-child relationship, but it cannot be secreting someone or hiding someone when that person has a cell phone?
An operable cell phone that they have used.
So everybody that has an operable cell phone can't be
No,
kidnapped.
the uncontroverted testimony, this was used the entire night,
Yeah.
that it also was set up and advised, the mom was advised to use it as a tracking device. And when she wanted to terminate this encounter, she was able to text her mother to let her know where she was, to 911, and then her mother again. So on those facts, also...
Wasn't it a factor to be considered when you talk about the facts in this case? Was there ever any evidence that the mother utilized the phone as a means of tracking the daughter?
Utilized it? No. But that's, again, like going to say...
If the call comes when the mother's asleep, is there anyone there to really answer the call?
But, Your Honor, the statutory language is secreting and holding in a place unlikely to be found. It doesn't say anything about...
But in fact, he was moving her around, and it took, even once the mother did start looking for her, it took a while to be able to track her down, and it wasn't until she left him and was hiding that her mother was able to find her.
I disagree that it took a long time. If I may finish the
Yes,
answer
you
to
may.
this. Thank you. The question, the evidence was that there was a text message when she was at the, I'm trying to get this right, the Salmon Club, and then the mother went to the Salmon Club. There was evidence that there was a text message that I'm at the camp store. She went to the camp store. These things were very quickly after the mother's receipt of those messages. Thank you.
Thank you. Mr. Rucci.
Good afternoon, and may it please the court. As this court knows, appellate inquiry as to the sufficiency of evidence adduced at trial asks whether, taking the evidence in the light most favorable to the state, the sitting justice at trial could rationally have found that Hansen secreted or held the victim in a place where she was not likely to be found. In admonishing this court to announce a broad categorical exception to kidnapping where a victim is left with the use of her phone, Hansen places respectfully too much weight on one discrete piece of evidence to the exclusion of all of the other evidence on the record. This court should hold that the trial justice rationally found that Hansen secreted or held the victim in a place where she was not likely to be found when he removed her from her bed and from her home in the middle of the night and drove her to various localities throughout the town of Eddington for the express purpose of keeping her from her mother and others whom Hansen perceived, however wrongly, to be dangerous. The evidence in this case is sufficient to support a conviction, irrespective of his leaving her in possession of her cell phone. Further, the path to legal parenthood in Maine is statutorily enumerated. The state in no way seeks to diminish the loving and important role of a step-parent in a child's life by saying that Hansen's interpretation of the statutory exception at play here is unsupported by local law and, from the state's position, the relevant statutory history, or by other statutes availing individuals responsible for the long-term care and welfare of a person of certain defenses or specifically implicating them in certain crimes. Appellant's argument is well articulated, it's expertly presented, and it must yield to the fact finder's role in assigning the weight to be given to any specific piece of evidence, and to the legislature's, from our perspective, narrowly circumscribed use of the term, and exclusively the term parent in the kidnapping statute. The verdict should be affirmed, and I would yield the remainder of my time.
Actually, I think that the language is, it's a defense to a prosecution under this section that the person restrained is the child of the actor.
You're absolutely right, Your Honor, and that is my mistake, and it is. It's that the person restrained is the child of the actor is the statutory
And that's
definition.
really the question, whether it is appropriate to consider this child to be the child of the defendant when she was not the biological child nor otherwise recognized as the defendant's legal child in any way.
Correct. The criminal restraint statute uses the opposite. It uses parent, but I was just writing too quickly, and I apologize.
If the mother had authorized Mr. Hansen to do what he did with the child, drive the child around, et cetera, would that have still been kidnapping?
No. You're acting under the express authority given by
Right.
the custodial parent, and at that point, there's other, factors that are implicated, such as is someone really secreted and held in a place not likely to be found. I mean, she could have said, in the face of an imminent danger, take the child and go, but that's acting under color of authority, and I don't see that as
And the
presenting
evidence,
the
as
same
I
issues.
understand it, is that Mr. Hansen was acting contrary to the mother's wishes, not in keeping with the mother's wishes.
That is what the evidence at trial showed conclusively, I believe.
Does the step-parent of a child have the same rights and prerogatives with that child if they're acting in loco parentis? Does
No.
that elevate it to the same level of natural parent?
From the state's perspective, no, Your Honor, because many people who are not parents or step-parents can be in loco parentis. If I bring my child to a daycare provider, that daycare provider is acting in loco parentis. If they take my child to another location and hide them and secret them in a place where they're not likely to be found, I mean, they're guilty of kidnapping. I understand that that's not the same statutorily, but it speaks to the same issue that you're talking about, Your Honor, where the two are not synonymous. In loco parentis does not mean that you have color of authority that is the same in part and parcel as the biological
What if he
parent.
was right? What if a motorcycle gang really was coming after him? The mother you can't find, and so he takes the child to protect her. Isn't that a violation under your interpretation?
It is, and I'm glad you brought that up, Your Honor. The competing harms defense under Section 102, as I mentioned in my brief, would provide the type of protection that defendant seeks here. If there is an actual harm, and this person who is acting in loco parentis, or is any person really is acting to save a child. If I pull a child off the street in the face of a shooting or something like that and run in the opposite direction, I would think that I cannot be prosecuted for kidnapping.
Mr. McNamara has posited, I might say, or described that if the child being ostensibly kidnapped has a cell phone, that's a magic get-out-of-jail-free card because that child can call for help. I'm probably misarticulating the actual argument, but what is the effect of the fact that a child who's old enough to use and understand a cell phone had access to it and in fact used it? Does that neutralize everything else?
It is but one factor in the sufficiency of the evidence analysis from the state's perspective, Justice Meade. For instance, this court had an entire record from which to draw its legal conclusions, and it drew those legal conclusions in saying that, in expressly considering the presence of the cell phone, and by saying that, this did undermine his criminal purpose, but not to such an extent that this is not a crime. He placed more weight, the justice, on the fact that this was at night, on the fact that the child was removed from the home, on the fact that the child was taken to various locations, which I would suggest is important when considering whether Ms. Hansen could have just gone out and found her child. And importantly, in his refusing to yield the child to the custodial parent when confronted in the middle of this incident, I believe at the Salmon Club, she says, "Give me back my kid." He says, "No, no, no," and drives away. Those factors would tend to support a kidnapping, and the justice was entitled to rely on those factors and weigh those more
If it's
heavily.
simply a factor, is there a circumstance you can think of where that factor would be predominant, and saying the fact that the cell phone is here makes this not a kidnapping case? To what degree would that factor have to embrace to produce that result?
Well, I think it would have to do more, Your Honor, from the state's perspective in where the child was than where the cell phone is. If the child's in the next room with a cell phone, then probably those facts are not going to support a kidnapping. But there is a temporal requirement, which is important on the face of the statute, taking a child and secreting them in a place where they are not likely to be found. Here, it took the better part, I'm not sure exactly how long it took for Ms. Hansen to find the child the first time when the defendant refused to give the child up and drove away, but we're talking about an incident that lasted something like 45 minutes. I would submit that that is a substantial period of time, that the child is unlikely or unable to be found because the locus keeps
So the fact that they may
changing.
have a cell phone and the fact that a durational requirement has been satisfied?
I think that's part of it, Your Honor, but I would also point the court to State versus Hague. In that case, you know, the child was put in a hotel room. This court found that the elements of kidnapping were satisfied because only the mother and the stepfather, who was the defendant, knew where the child was. But there was, I mean, the evidence, I don't know if the evidence was on the record, but every motel room does have a phone. Every motel room does have a front desk.
Well, what distinguishes this case or this situation is it's a cell phone with a tracking device.
Correct.
And this defendant was mobile, but what if he just took the child to a stationary location? Likely to be found, I mean, it's pretty easy to track a location of a cell phone, isn't it?
I think what really distinguishes this case, Your Honor, is the fact that there's no evidence that, well, it's the state's burden to produce evidence, so I want to be careful how I say this, but I think the record would suggest that Ms. Hansen was asleep. So she's not, irrespective of the fact that there is location tracking on this phone, she's not getting any of that. The court, you know, found that this happened in the middle of the night, and I think that's important. But I want to be careful about suggesting that there's any, you know, hard and fast line where certain actions taken or not taken, leaving the cell phone or not leaving the cell phone is dispositive, because I just don't feel that that's the case.
You think it's just really a totality of the circumstances, and that in this case, despite the fact that there was a cell phone, that the defendant knew she had the cell phone, there was location tracking on it, she in fact was texting her mother during a lot of this incident, that that may not mean that she was necessarily being held from others or secreted from others, but also that it's really just the totality of the circumstances, the fact that they were moving around, that he refused to return her, all those other things.
Right. My point, Your Honor, is that all of those things that you just mentioned, respectfully, could cut in favor of a defense. But do they compel the conclusion that there was no kidnapping here? That's really what we're asking. Based on the totality of the record, is the contrary conclusion to that reached by the trial justice compelled? And I can't envision every scenario where leaving someone with a cell phone might compel the finding that kidnapping did not happen. But what appellant is asking you to do is saying, working cell phone, effectively craft a defense that applies in every case where there's a working cell phone. I believe there was another, and I don't want to mischaracterize his argument, there was another prong to that. But from the state's perspective, it's the totality.
So in this case, I think Hansen testified that he didn't think that the child would use the cell phone to call the mother. So going to the element of the offense in a place where the other person is not likely to be found, do we use an objective or a subjective standard? In other words, does the person have to think, I'm putting this person here because I don't think she's likely to be found because she's not going to call her mother? Or do we use an objective standard? We look at the whole picture there and say that the fact that she had a cell phone was a factor to consider in whether or not she was or was not likely to be found.
Well, I think it would be an objective standard, I believe, Your Honor, but regardless of whether you apply an objective or subjective standard, in this case, same result. Objectively, he's moving her throughout the town. Very difficult from the state's perspective to find her given the facts on the ground. And from a subjective standard, yeah, you're right. His position was, I don't think she's going to try and find her mom. His position actually was, he felt that she was so comfortable with him that when she disappeared from the truck after he got out to try and make entry to some sort of building.
I may not have stated that correctly. What I'm getting at is his subjective state of mind, whether he thinks he's taking the child to a place where she's not likely to be found. hypothetical example, let's say, and this is kind of fantasy, let's say there's someone who's not familiar with how cell phones work and takes the child with the cell phone. We know that she's going to be tracked and she can contact it, but the person driving thinks it's a video game or something like that. Does he have to understand or not understand? I guess going back to Mr. McNamara's point, he says that he knew the child had the cell phone was there, and therefore that factor is obviated because the child was likely to be found because she had the cell phone.
It's a difficult question, and I guess my answer would be that I don't think the fact that the person may or may not have a working understanding of technology would provide a defense in the case. The state has to prove that he acted knowingly. He clearly, based on the facts in this case, Mr. Hansen it would suggest that he was laboring under some mistaken apprehensions, perhaps some paranoia. The court nonetheless found that he was able to act knowingly, which is supported by the record. If there are no further questions, I'll
There
yield
don't seem to be. Thank you.
yield the remainder of my time. Thank you.
Thank you. I go back to this point of the 1970s and the desire to not make kidnapping overly broad, and the notion that this is literally a tracking device that is capable of tracking an individual at every moment they're gone. It's just the language.
And everybody has one.
Right.
I mean, so what you're really suggesting at this point is that, I mean, there are very few people in this state who do not have cell phones.
Right, but when you're being kidnapped, our conception of being kidnapped and secreted and held in a place where you're unlikely to be found precludes that. That is just, it's antithetical to the possibility of being secreted and held in a place that you have a tracking device. And I see this case where Mr. Hansen is an individual serving a 12-year sentence for intending to protect his daughter, for his stepdaughter, if that makes a difference. And that is, to me, just an indication of a case where we have jumped the shark in what our understanding of kidnapping is, whether it be because of the child of defense or this notion that she had a cell phone that he permitted her to have and that she was able to make a phone call. The judge even wondered, why didn't you make a phone call to your mom? You could have woken her up in the middle of the night rather than the buzzes on the text. That is a big, I'm not saying that Mr. Hansen is innocent of everything. He should have been. It could have been charged with criminal restraint, a Class D crime.
But isn't it really a question of all of the facts? In other words, had she immediately called her mother, woken her up, said, "Mom, I'm here," et cetera, then probably the state would not have been successful in making out the elements because it wouldn't have been secreted for a sufficient period of time, et cetera. So, I mean, isn't it really based on all of the facts?
No, I think it needs to take into account the actions of the defendant and not the actions of the victim here. The victim could have made phone calls, could have texted 911, could have decided not to go in the first place. All of these facts could have happened, but what the defendant did was permit her to have a tracking device and a tether to society to be able to call that all of us who grew up before cell phones could not imagine just fathom being kidnapped with having that ability in our hand.
It sounds like a bright line rule. If any kidnapped victim has a cell phone with the permission of the kidnapper, it can't be kidnapping.
Well, no, I think there's the tracking device testimony that we have here. I think there's the continual usage of the cell phone. There's the additional fact that that's how she was found, both by her mother and by 911. And it's being capable of being used. It's certainly within defendant's knowledge. I think there's a lot of facts here, and there's no bright line rule. Thank you.
Thank you. Thank you, counsel. As is our usual practice, we'll take the matter under advisement and issue a written decision in due course. With that, we will be in recess on this matter.